Okay, so essentially the law says you mustn't do it, and you mustn't do it by reference to certain specified drugs and in relation to certain specified levels that you're allowed to have in your body before you commit an offence. This brings us into line with the position that's been extant on the continent for some years. In order to make it easier for us, or perhaps for themselves, Parliament has simply crowbarred into the existing Road Traffic Act 1988 a new section which does little more than mirror the existing section dealing with excess alcohol, essentially making the law relating to excess alcohol now relate to driving with drugs as well. The thrust of the legislation was always aimed at those driving with illicit substances in their body, cocaine or cannabis or whatever it might be. But the list of drugs is quite extensive. It's about 15 or more the last time I looked, and does include drugs that can be lawfully prescribed. Yes, there are very precise limits, so for each and every drug that's prescribed, there's a particular limit above which you will commit an offence if you have more than that level in your body. There is a specific defence in the new legislation with reference to those on prescribed drugs, and the defence states that if you are in receipt of a prescribed drug and you follow both the instructions in the prescription and any additional instructions given to you by your doctor or dentist, then that's a defence. There are essentially two differences, one minor, one much more important. The minor difference is a procedural difference. In order to obtain evidence of the drug, then a blood sample has to be taken. With excess alcohol, of course, for many years now, the principal sample, at least in the first instance, will be a breath sample. That's not so important. What is more important is what is not written down anywhere. And that is that when the state tests for whether someone has more than the allowed amount of alcohol in one's body, then they do exactly that. They test for the amount of alcohol that's left in your body. And if you are above the prescribed limit, your ability to drive will be curtailed to a greater or lesser degree. That varies from person to person, but whoever you are, you will fall somewhere in the range that means that your ability to drive is in some way impaired. That's not quite the case with drug driving. Firstly, the limits are set very low indeed. Secondly, because there are so many different drugs and drugs themselves are more complex, what the law tests for are not just the drugs themselves, but also in some instances the byproducts of their decay and their metabolizing through the body. And that means that you could find yourself above the legal limit hours, or in some cases even days, after you've taken your drug, and indeed hours or some cases even days after any intoxicant effects have worn off. Cannabis in particular stays in the body and can be traced as having been taken sometimes for up to days after it has. And regular cannabis users are probably almost never able to drive lawfully because they are probably almost permanently above the limits as they are currently set. Yes, Section 3 of the Road Traffic Act 1988 specifically sets out that if you are under the influence of drugs, or for that matter alcohol, and you kill someone whilst driving carelessly, then that's a specific offence with, of course, an enhanced penalty. Well, the law mirrors the case for drink driving, and the penalties are the same. So in the first instance, a minimum disqualification of 1 year and a fine or imprisonment depending upon the severity of the offence. For a second or subsequent offence within 10 years, a minimum disqualification of 3 years and an enhanced penalty.